Thank you, Bita, so much for joining us today. Now, I want to do some hard-hitting questions here for realtors with regards to landlords and tenants, because I see a lot of mistakes happening out there, and it's really dangerous for the realtor and their landlord client. So let's get into this. I mean, I know you see it too, because when you're in court, a lot of times it's because the realtor made a mistake. So Bita, let's talk about, I guess, the most common questions that new investors who suddenly become landlords need to know, because really, even today, we're just scratching the surface of everything you need to know. That's why your business is so viable, because you specialize in this stuff. But for example, a lot of people don't know what happens if my tenant stops paying rent.
That is a great question. That is one of the common questions we get asked all the time. And before I get too deep into that, I want to say that as a landlord, anytime you purchase rental property for the purpose of rental income and you become a landlord, you're taking on a risk. One of those risks are non-payment of rent, right? Another one is damages. For non-payment of rent, you have to go through a process, meaning you have to go through a procedure to get the tenant out, which means you have to serve notice, file it with the board, and then wait for a hearing. And then on the day of the hearing, you can inform the board or update the amount of rent arrears owed from the date that you served the notice to the date of the hearing.
Thanks, Peter. But who can fill out the forms? Can your realtor fill out the forms?
I highly recommend that the realtor stay away from serving or on behalf or for their clients.
Well, we're not allowed to. I don't think realtors.
You're not allowed to for many reasons. Number one, you're not licensed to do so. Number two, your errors and omissions insurance does not cover you. Number three, you're opening up yourselves to liability and the brokerage to liability. And number four, you don't know what the requirements or consequences are.
Okay,
so
a landlord isn't going to know either. So then how do they make sure that they're crossing the T's and dotting the I's?
Well, that's exactly it. Because once the realtor does this and they apply to the board and it goes to the board, if there's one error, Sandra, no matter how minor, you forgot the postal code, you forgot the city, you forgot to put basement apartment, you forgot to put the unit, that matter will get dismissed.
Right.
Guaranteed.
Yes. So a landlord has a tenant who isn't paying, and there's forms to be filled out. What does the landlord do? Does the landlord fill these out on their own?
The landlord can fill it out on their own, or they can contact a legal representative to do it for them.
So a lawyer?
A lawyer can. Usually lawyers don't practice in this type of law. Paralegals are the ones that practice in this type of law, just because it's not really worth it for lawyers to do. But there are lawyers who practice in landlord and tenant board tribunals.
But they're not really specialists. Your lawyer, your real estate lawyer, is not a specialist in this.
No.
What I'm trying to say is they have to reach out to you, Bita.
Yeah, they should be reaching out to us.
Yes,
we are your guys.
Because most landlords won't be able to fill out the forms appropriately. And even, see, I've been on the website and it says, oh, okay, non-payment, fill out this form. But it doesn't tell you then that you have to register it, right?
That's right.
It doesn't tell you every step. So the poor landlord thinks that, oh yeah, everything's done, I filled out the form. No, you're just starting.
That's right. And those notices have deadlines. They have requirements. If those deadlines are not met, and I'm talking about applying that notice to the board within the time period that you're required to, then there's another error. You haven't followed procedure properly. Remember, you're dealing with a government body. And in government, for those of you who are familiar, you have to follow procedure properly.
Definitely. Right. So how can you terminate a tenancy?
Well, that's a great question. A lot of realtors or even landlords, they find that, they call us and they say, well, my tenant isn't allowing for showings. Can we end the tenancy, or the lease is coming to an end? Can we kick the tenant out? There's only three ways to end the tenancy. Number one, if the tenant decides to leave and gives notice. Number two, mutual agreement. Or number three, by way of a court or board order. That's it.
So
That's
when you
it.
say mutual agreement, what does that look like? We just verbally agree?
You verbally agree, and then you have to draft an agreement or go, contact the legal representative to, fill out the appropriate agreement, sign it, have all parties sign it, and then, which a lot of people don't know, Sandra, they have to file that agreement with the board. Because at the end of the day, we are all people. People change their minds all the time. What happens if that tenant changes their mind and you don't file with the board? Well, an
Exactly.
agreement has no enforcement behind it until you have an order.
And I think
Makes sense?
that's the step that a lot of people don't know about, because when you go on the website, it's not clear.
That's
There's
right.
no
That's
flow
right.
chart, right? First do this, then.
Oh, that's right. That's right.
So this again is why they should be hiring you. So what is an illegal deposit? What are illegal deposits?
Okay, so let's talk about that. Legal and illegal deposits. Legal deposits, a landlord can collect a deposit on or before the start of a new tenancy. That deposit cannot be more than 1 month's rent, and it cannot be applied to anything else except for the last month of the tenancy. So I know that common practice when you're looking at a rental property with the realtor, you put a first and a last deposit to secure the property. Really, the first month's rent is not due until the first day of the tenancy. But legally, a last month's rent must be provided to the landlord. It can be kept for the to be placed towards the last month's rent. There is an exception for other deposits, being a key deposit, a refundable key deposit. The Ontario Standard Lease has a section where parties can agree that the tenant will provide a refundable key deposit. Now, that key deposit can only be for the cost to replace that front door key. Not the garage door remote, not the fobs, not the locker room key, not the party room key. You see where I'm going with this? Only the key for the front door, not the locking mechanism, not the hinges, just the front door key. Any other deposit is an illegal deposit, cannot be obtained by the landlord or held by the landlord. In fact, if the parties voluntarily agree to a higher deposit or a further deposit, which is an illegal deposit, that tenant can bring an application to the board and request a refund, which I find is happening nowadays because rentals are just going multiple.
So when you're moving into a condo, you need a fob, and it's like $100 or $150 for that fob. So the landlord can't get the deposit for that?
Not a fob, a key.
So
Yeah.
so the garage door fob, nothing like that. However,
Remember we spoke about the risks, Sandra?
yeah,
This is another risk, right? It's the cost of doing business.
exactly. So now I know a lot of landlords want post-dated checks. Now, can they demand a certain form of payment?
That's a great question as well. In accordance to the Act, and I know that in the Ontario Standard Lease, there's a section that parties can agree to a method of rent payment, and usually it's post-dated checks. In accordance to the Act, a landlord cannot demand a method of rent payment. If the tenant changes their mind and says, hey, I don't want to pay by post-dated checks, I want to send you an e-transfer, then the landlord has to accommodate for the tenant to pay their rent by any way that they're comfortable making the payment.
Okay. So, I mean, not too many people use checks anymore. So we've been seeing more and more e-transfers, which doesn't give the landlord any confidence that they have the next month's rent already in their possession, ready to be deposited on the
But
first.
neither does a check.
Yeah, because they could bounce, right?
It bounce. But I'm a huge fan of e-transfers. I'll tell you why, Sandra, because number one, I like to automate. So, and then make it easy. Number one, the tenant will send the rent, it automatically goes into the account. There are no holds, and the tenant gets notified and is provided a receipt. So I don't have to make time out of my day to provide them with a rent receipt.
Yeah, okay. So that's interesting because this is an issue. A lot of times we see landlords demanding things that are not within their legal rights. And so if in an agreement, it says something like, I want to get to the no smoking and no pets kind of thing, because that's a real big issue. But if in the agreement, it says the tenant agrees to do this, this, and this, and the tenant knows that it goes against the code, and the tenant signs the agreement anyway, what happens then? Can the tenant then say, well, I don't need to follow that, or what happens?
Yeah, they can.
Yeah.
So let's talk about the lease for a minute. Okay. So the lease agreement, I call it the rules of the game. It outlines the rules. Who are the tenants? Who are the landlords? Where's the rental property? How much is the rent? What does the rent do? So forth and so on. Parties cannot agree to give up their rights under the act, even if they sign. That includes a pet, not having a pet, right? There's nothing that a landlord can do. If there's a term in the rental agreement that's inconsistent or contrary to the act, that term is automatically void and unenforceable.
So let's talk about pets, because a lot of landlords will say, I don't want any pets. But unless the condominium rules are no pets, what can the landlord do?
That's the exception. Condo rules or condo corporation has their own rules regarding pets, and that needs to be clarified, and make sure you provide your prospective tenant with a copy of the rules. And make sure they initial next to the no pet clause. The law says that a tenant is allowed to have a pet. So even if the parties agree and you enter into a tenancy, and then the landlord comes to do a repair 3 months after, they find out that there's little Fluffy in the property, they can't do anything, even if the parties agreed. And that's what I find is happening now, Sandra. People are like prospective tenants are lying on their applications because landlords are restricting them. I can answer if it is a dangerous pet. Then the landlord can apply to the landlord and tenant board, have the matter heard, and then have the board decide the fate of that application. But I have to say, just because a breed says that a pet is dangerous doesn't mean that particular pet is dangerous, because the board is not going to say, well, Sandra, you have a pit bull, get rid of it. No, the board's going to say, Sandra, I see your little Fluffy. Has Fluffy attacked anyone? Is Fluffy friendly? Is Fluffy around children? It really depends on the owner than on the pet. So the board, there are other factors at play, even with a pet that's a dangerous animal.
Right. Like, would boa constrictors be considered dangerous?
They can, but they're considered dangerous if they are set free, right? I mean, they can go through pipes and up toilets. We've had happen.
I don't want my next door neighbor in a condo to have a boa and it escapes and comes through the vent into my place, right?
That's right. That's right.
Okay, so the rule is they can have the pet if the pet has either been known to be dangerous or then becomes dangerous, then it must be removed.
Yeah. Unless that dog or the boa has physically attacked someone, then the board will take it a little seriously.
Well, with the dog, usually there's a muzzle order on the dog, right? So then going through the common areas, you'd have to have a muzzle. Now, I think there's another exclusion if they're living in the same house, like let's say it's a triplex and it's shared HVAC and there's a serious allergy. Then the landlord can say, my tenant on, unit 2 has a serious allergy, or if you're moving into my house with me, like you're in an auxiliary apartment, I or my child has serious allergies, so you can't have certain pets.
So you have to prove that serious allergy.
Right.
Okay. There has to be some sort of a medical report, an updated medical report proving the allergy, perhaps medication. I mean, anyone can say they have an allergy, right?
Okay. What about smoking?
Smoking. Let's talk about that. Smoking. The act doesn't make direct reference to smoking. What the act says is that if a tenant interferes with the reasonable enjoyment of other tenants or the landlord, then the landlord can apply under the act to terminate tenancy. So if, for example, you have someone that's a fiend and smokes like crazy, and I guess the smoke is going through vents and interfering with another tenant's enjoyment, well, then they can bring an application. But I'll tell you, from my experience, proving an odor or a sense of you have to prove how that is interfering with their enjoyment. Right? Secondhand smoke, I mean, It's a health concern. But smoking is really difficult to get an eviction on at the board.
Unless it's a non-smoking building.
Unless it's a non-smoking building, which you should know beforehand, so
Yeah.
you let the prospective tenant know.
Exactly. Okay, so a lot of landlords now want to sell their property and they just want to evict the tenant because it's going to be easier for showing. They can fix it up, do some staging, and easier to show, easier to sell. Let's talk about that because that is a cesspool.
Yes, it sure is. Well, I'm a huge fan of cash for keys, a huge promoter of cash for keys, especially when it comes to these type of situations, because there is no other way to get a tenant out because a landlord wants to sell. During COVID, especially, Sandra, the number one challenge that a lot of landlords were facing was access to the property. Just because everybody was working from home, schools were being, online, and people didn't want prospective buyers walking into the property, especially during COVID while they were working or they were doing online schooling. So a lot of realtors were saying, well, they're not allowing for showings. Well, the only way to get them out really is to pay them out, cash for keys. And cash for keys is basically offering a buyout in order for in return for a termination of tenancy.
Right.
Realtors, landlords, do not do this yourselves. You don't really know what you're doing. And then you call me and you say, well, I negotiated and the tenant didn't leave and I paid them. And then it's too late because then you're in a bigger mess.
Yeah.
So cash for keys is definitely the way to go prior to you listing the property.
Yes.
That way, once the tenant is out, you can do whatever you want. Exactly. You can stage it, paint it, change the roof, give it curb appeal. You're not going to have access with, requested showings, restrictions. You're not going to have issues with vacant possession. You're not going to deal with any of that stuff.
Mm-hmm.
Get them out.
So cash for keys is one of the ways that you can terminate an agreement. And let's say they signed a 1-year lease, the tenant and the landlord, and in month number 9, the landlord suddenly has to sell the property. Can you still agree?
Yes.
Even though it's during the time of the tenancy, the term? Yeah,
absolutely. We call the shots. That's another reason why I love cash for keys. Cash for keys can be done within the lease, after the lease, without a lease. Like, it doesn't matter. We call the shots. And the best part is you have an influence on the outcome.
Yes.
Right?
Yeah. It can be expensive, but when you're selling property in Toronto, for example, it could be worth it.
Be worth it. Absolutely.
Because a lot of times the rent doesn't cover the monthly expenses for a new investor to take on your tenant, right?
Right.
And please don't try to lie. You've got a tenant that hasn't paid in 6 months and now you're just going to sell and you're going to lie to the prospective buyer, landlord that, oh yeah, they're good. You're going to have to prove that they've paid. So
yes,
you can't lie your way out of that one. So that's an unfortunate situation that I hope nobody ever gets into. I want to talk about typical duration of leases. Now, most people want 1 year, but I see a lot of people landlords asking for multiple years. And personally, I don't think that's a good idea. So what do you think of like 2, 3, 4 year leases?
I don't think that's a good idea at all. At all. No, because you're tying. See, I'm not sure why landlords think this way. They think that if they can lock down a tenant for 2 years, then they're guaranteed rent for 2 years. And no, you are basically tying yourself down, because what you're saying is, I can't sell the property for 2 years. I can't move into the property for 2 years. That's what you're saying.
You restrict your options.
That's right. No one benefits from a lease except for the tenant.
Exactly.
Because they are the one that guaranteed housing for 2 years.
That's right. That's right. So, and also after the initial term, whether it's 1 year or 6 months or 2 years, whatever you've decided, it legally goes to month.
Correct.
Can a landlord insist that the tenant sign another lease for a 1-year term, for example?
They can ask, but the tenant is not obligated. I don't know why they would even want to sign another lease. It doesn't make sense. But if
Okay.
that's what they want to do, they can, but the tenant is not obligated to sign a new lease.
Tricky situation. 2 people are on the lease, and after, I don't know, 2 years, so the lease term was 1 year, say, now it's month to month. One of the people moves out. Do you have to change the lease to have just the one person on it?
No, that person, well, first of all, if you're still within the lease, both parties are legally and severally liable for that lease. At the end of the day, it's still a contract.
Right.
Right?
What about
But
after the term?
after the term, that person who's on the lease can just carry it forward. That's fine.
Okay,
The
so it
remaining
doesn't
person-
matter that you have this person that's been living there for 5 years, it's gone month to month 4 years ago, and the other person's no longer living there. That doesn't matter.
Correct.
And
That
so
doesn't
that other person is no longer obligated.
No. No. Once the lease is on month to month, then it's expired. That if that person moves out, there is no contractual obligation between them and the landlord.
Okay. Now, when you take that last month deposit, a lot of landlords don't know that you're supposed to be paying interest on that, right?
Yes. Yes. That's a great one too. Yes. Most landlords don't know, and and it's fine, but you can pay interest on the last month's rent deposit when the tenant moves out as well.
And topping up the last month rent. So for example, in 2018, they gave you $2,000 for last month rent. By the time they move out, rent is now $2,300. So how do you deal with that? The increase in rent on the last deposit plus the interest. It's a lot of accounting for a typical person who owns one rental building or multiple and is a busy person in life. So what's the best way to deal with this? That is within the law.
Well, remember, you have to treat this like a business. So you have to make time for your business. But anytime you serve notice for rent to be increased, you can ask them to top up the last month's rent deposit. Ask for a top up. If you don't ask, you don't get.
Okay, so you ask for the top up and then you pay the interest. It's usually around the same amount, right? So at the end of the day, if you didn't pay the interest, it's a wash, right? Pretty much.
Yeah.
Okay. Yeah.
You can't put the responsibility for repairs on the tenant. You can't put the responsibility to change furnace filters on the tenant. Furnace filters are responsibility of the landlord. You can't say, hey, tenants, shovel the snow and maintain the property, and just send me the rent. You can't, you have to treat it like a business, and you have to be hands-on. And I'm really hard on my landlords. And I say, if you're not prepared to do this, get out of the business.
Yeah.
Get out of the business.
But isn't there a way to compensate your tenant for clearing the snow?
There is
legal.
There is, but you have to have a separate contractor's agreement. The tenant still has to agree, right? And you have to pay them compensation to do it.
So
It
can't be in the lease. It has to be a separate contract.
Correct. Remember, clauses that are contrary to the act in the lease are unenforceable and void. That includes snow removal.
Okay. Can a landlord who owns a single detached home that is subject to utility bills like water, sewer, garbage collection, charge the tenant for that? Can that be the tenant's responsibility?
I mean, they can agree to that, but I mean, utilities you can agree to. So water charges you can agree to, hydro you can agree to, heat you can agree to. Equipment, mechanical equipment. Let's talk about that, such as the hot water tank. The hot water tank, I mean, there's a rental fee. If it's a rental, you cannot request that the tenant pay that rental fee. The tenant is not obligated to pay, a fee to maintain the landlord's rental equipment.
Okay, so that would include a heat pump if there's an extra charge on a condo or whatever. That should just be included in your rent, your numbers, see what you can get for rent and cover that. So that also includes maintenance fees. You are not allowed to require the
That's
tenant
right.
to pay your maintenance fees. And even if the maintenance fees and property taxes and, you know, some equipment rental and everything went up beyond the allowable increase in rent, because it's prescribed by the government, right? Every year
Yeah.
it's different, you have to check. So even if your cost now went above, let's say they increased 3% and you're only allowed to increase 1.8%, you cannot ask for the extra money.
Cannot. The tenant is only responsible for rent and or utilities. That's it.
Let's talk about section 3 in the standard lease. Now, if they have said, and correct me if I'm wrong, if the tenant has agreed to receive notice by email, you can serve notice by email that tomorrow, 24 hours from now, there's going to be a real estate showing. Is that correct?
Well, let's talk about that, because even if they agree to that on the lease, the appropriate document that needs to be filled out and signed by the parties is the consent to service via email form. It has to be on the landlord and tenant board form. You can get that on the landlord mastery guide. That's going to be a link that Sandra will have. So that will give you, I mean, that you can definitely attached to your lease as an appendix. That way, parties will agree to receiving notices via email. But Sandra, if the tenant says, Sandra, I don't want to receive email notices anymore, then you have to go there and physically post it on the door.
One of the things, though, to protect landlords and protect realtors, we're seeing a lot of fraudulent documents. So what can a realtor do to either verify or make sure they're not getting fraudulent stuff?
So, Sandra, besides the normal things like requesting proof of income, asking for pay stubs, if the tenant provides them, here are a couple of other ways the realtors can vet prospective tenants in order for them to confirm those documents are valid or not. Social media is a big one. Facebook, Instagram, check prospective tenants out on social media. Social media is their life on the internet, right? Social media is huge. Another tool, Google the name of the prospective tenant. You will be surprised what will come up. Another couple of websites. First one is canly.org and openroom.ca. Canly.org will give you access to orders online. Canly started uploading landlord and tenant board orders going back to August 2022. But openroom.ca is a private website that allows landlords to upload orders. So it's great. You can go into openroom.ca and put in the tenant's name, Sandra Renamato or Joe Blow or whoever it is. And if there's a keyword that matches that name, it'll pop up. Well, don't you think it's important to see if there are any orders against the prospective tenant? These are two great tools.
I've been waiting for a website where landlords can put information like that to help each other. It's like, avoid this person because this is what happened. So, wow. Okay, that's amazing. I'm going to include those links in the download that you can get. So make sure that you click for the download. Okay, thank you so much. Awesome. So another thing we see is this. Property goes for sale and it's tenanted, and you call the listing agent and they say, well, the tenant will stay or go. It doesn't matter. Like, wow.
Yeah.
Right? Yeah, but no, they're really nice people. Yeah, they're nice until you tell them that they got to go out and pay more rent.
Right. That's exactly it. That's exactly it. Selling a tenanted property. I mean, where do I start? The only options that a landlord really has is, number one, to serve notice after you have a firm agreement on purchase and sale, or number two, cash for keys. Yep. Neither which should be done by realtors, right?
That's
Neither
right.
One.
That's key. Please say that again. Can the realtor fill out the forms and do this?
No, don't do it.
Can the realtor negotiate cash for keys?
Oh, please don't do that. I had a really huge realtor, like really he was top producer, very well known. He thought he was a big shot. He negotiated a cash for keys with a tenant. He gave that tenant $24,000, didn't get something in writing. On the day of closing, guess who didn't vacate the property?
Ouch.
Right? Don't do it. It doesn't matter how big you are in the industry. Just because you're big in the industry doesn't mean you know what you're doing.
Hey,
Right?
look,
Don't.
guys, I'm going to tell you advice as a real estate broker, and I've been around 25 years, and I can tell you realtor make mistakes. So please advise your clients to hire Stonegate Legal Services because it will go smoothly. The process will go smoothly because you know that it's heavily weighted in favor of the tenant. So if a landlord does have some rights, if they fill out the form wrong, or if you fill it out for them, I'm sorry, it's getting kicked out. It is getting kicked out if there's a problem. So Bita, talk to us about the forms. Who can fill out the forms?
The landlord or their legal representative. That's it.
Legal representative. That's it. We are not the legal representative. We have no business filling out those forms. You will find
for
out
many reasons. For many reasons. Number one, you're not licensed to do so. Number two, your errors and omissions insurance doesn't cover you. Number three, you're opening up yourselves and the brokerage to liability. And number four, you don't know what the requirements or consequences are. And you know what, Sandra, I'm seeing a lot of realtors serving the N12 notice because they've sold the property. And they're saying that the purchaser requires possession, so the tenant leaves, and guess who re-rents for a higher amount? But that's not the worst part. Here's the worst part. The tenants have the right to bring forward a bad faith application, which they are listing the agents as parties because the agent was the one who served the N12. And guess what, agents? If your insurance doesn't cover you, guess who's going to pay out of pocket? So that commission check that you worked so hard for, you're going to have to pay it to the tenant.
Yeah.
Don't do it.
And the tenants know the rules.
Oh, yeah.
We don't. They know.
They are way more savvy than a lot of landlords. Even they are more savvy than a lot of legal representatives. Never mind, right? They know.
Oh, hey, for them, it's a business, right? For the, the ones that have malintentions, it's a business for them, the tenants, right?
That's right.
Protect yourself, protect your landlords. So even an N11, so this is the one where you agree and it's all nicey nice, you sign. There's another step, isn't there?
Huge. That N11 has to be filed with the board.
Yeah.
If it's not filed with the board within 30 days after the termination date, that N11 becomes void automatically. But here's the worst part. The tenant has the right to file a motion, and a motion is basically asking the courts to do something, to put a hold or stay on an eviction for whatever reason. The realtor forced me to do it. The realtor came to my property and said I had to move. I didn't understand what I was signing because the realtor didn't explain it to me. And guess what? And I just got one this morning on my desk. The realtor forced me to sign the N11. And guess who's not going to be closing?
Yeah.
But
the realtor can't be involved anyways. What if it was the landlord that served the N11? Can they still go to
They don't have to sign it.
No, but if they did sign it, can they get a stay?
Absolutely, they can.
Okay.
But what I'm telling you,
I felt threatened, and
that's right. More and more, what I'm seeing is the realtor pushed me to do it. And remember, it's because realtors are salespeople. You have an interest in the sale of the property.
Oh, yeah.
Right?
Okay.
Don't do it.
I also want to explain the difference between N11 and N12 is N11, if everything goes smoothly, there's usually not a court case involved, other than the one that you just mentioned. Okay.
Yeah.
N12 says right on it to the tenant, you don't have to agree to this.
Bingo.
Right. The
N11 is an agreement. It's like the mutual release. Okay. The parties mutually agree to give up their rights to the agreement of purchase and sale. Right. The N11 is like a mutual release. The parties agree to give up their rights under the lease. The N12 is a notice. I'm putting you on notice that you have to move because the property is sold. But the N12 also says, even though the property is sold or for whatever reason, you still do not have to move for whatever reason.
That's right. Which involves a court case, and you may or may not win. Your landlord or buyer may not win. So in the agreement of purchase and sale, because I know Rob, your partner, was a realtor for a while. So in the agreement of purchase and sale, how do you cover off on that? Because we see the offers going in or coming in saying, okay, the buyer wants it for their own use. They're prepared to sign the affidavit and all that. The landlord has to serve the N12 because the buyer doesn't own the property yet. So they have no rights. It's like me serving a property, whatever. So all of a sudden now, the seller cannot provide vacant possession. What kind of a clause could we have added, either as the buyer rep or seller rep, to protect the landlord? Like, can we say, if the landlord can't provide vacant possession, the buyer can back out with no penalty? Or the landlord can unilaterally extend the closing date to provide vacant possession if the buyer doesn't want to take it on. And I recommend the buyer doesn't take it on.
100%. I recommend that too. You can add an extension clause, but there should also be a direction in the agreement of purchase and sale using the VAC-1 buyer's direction clause. In the Real Web Forms library, there's a VAC, vacant possession 01 clause. Use that clause, because that clause basically says the buyer directs the seller to serve notice.
Right.
That the buyer requires possession. So that means the only reason why the seller is serving this notice is because the buyer requires, they want to move in with their family.
Yeah.
If the tenant moves out and the buyer does not move in and re-rents, the seller lifts the liability from themselves and is putting it onto the buyer. It's a great clause.
Yeah. You can't serve the notice that the buyer is going to take possession of the suite without having it in writing, right?
Bingo.
The buyer has to direct you to do this because they're the ones who are going to be on the hook if they in fact don't move in.
You got it.
Furthermore, if it does go to court and then the buyer says, well, you know what, I've decided I can't wait that long, so I'm still going to buy the property, but I'm just going to rent it out anyways, that court case has to be terminated. Like that file has to be terminated, right?
That's right.
Okay. Now, sometimes realtors are pushed around from their landlords. I'm sorry to say it, but they are. And the landlord says, you know what? Pretend my son's going to move in and just serve the notice that way. Let's just do that. First of all, you shouldn't be serving the notice. But let's say their intention is to dupe the tenant, either to get more rent or then to sell the property. So the landlord knowingly lying to the tenant saying, either we're going to use it for immediate family or yeah, that's it. I'm going to use it for immediate family, but either they just want to raise the rent or they want to sell it. So what should you as a realtor do?
Well, as a realtor, don't do the notice for them. What I'm noticing a lot is landlords saying, well, realtor, fill it out. I won't live here because I have another house. I will just stage it to make it look like I live here. What realtors need to know is that there is a test to bad faith. And I can guarantee you're going to be listed if you put pen to paper on that N12. There is a test to bad faith in accordance to Section 57 of the Act. You cannot lie or you cannot stage the property to make it look like you're living there.
Yeah. Don't do it, guys. Don't get involved. Your license is not worth it. The penalty is not worth it. The headache of having to go through that court case on behalf of, for the sake of one commission, it's really not worth it. Conduct your business the way you want, but you heard it from me, broker of record. Don't do it.
Don't do it. Don't do it.
You can never fill out those forms. So it's not even a question of you being able to fill out those forms. But if you are going to then rent the property and the landlord said, I filled out the forms myself. I know how to do this. And I'm going to say my son's moving in, but really we're not. We're going to sell it after. Oy. Don't do it, right?
Re-renting the property is not personal use. That's right.
That's right.
That's right.
There is a time though where rent control doesn't kick in, and that date is. Do you want to remind us of that date? If the building if the unit itself was occupied post this particular date, it is not subject to rent control. What's the date?
November 15, 2018.
It's kind of like not November 1st, November 15th.
That's right. That's right. That's right. That's a big one. Occupancy, keyword occupied. Okay, after November 15, 2018. So for example, if you have a 10-year-old house and you never finished the basement and it was built, let's say, well, it can be, if it was built in 2016 and you've never finished the basement, nobody's ever occupied the basement, but you finished the basement this year, it's not subject to rent control,
Okay.
right?
Okay.
It's
There-
occupied.
There is a bylaw when you build an infill, let's say, so you tear down a house and you build it and you put 2 units in it. There's a bylaw in Etobicoke, at least, even though it's part of Toronto, that you cannot rent out that auxiliary apartment for 1 year.
Oh, I didn't know that.
Which is, well, it's part of the building code, which is, I was surprised to hear it too, because it kind of goes against what Toronto's trying to do, and that is open up
Yeah.
apartments for people, right? So
Oh.
now that information came to me 2 years ago, maybe it's changed now, but just be careful if you, as a realtor, have someone who's building a place and they're going to put 2 units in it and they're going to rent out their basement or something, check with the building.
Yeah.
Now, in order to get the building permit to put an apartment, they are probably notified of that. And the architects, local architects will know it too. But realtors need to know that too.
Yeah. Yeah.
Okay. What is another mistake you see realtors making?
Another mistake that I see realtors making is, besides filling out the notices, is trying to negotiate a cash for keys with the tenants. Cash for keys is not the same as selling the property. Negotiating with the tenant, and the attitude is such that, well, if I can't sell a house, I can negotiate a termination of tenancy. It doesn't work that way. It's a totally different beast. Tenancy laws in Ontario are the most restricted and governed law in all of Canada, especially the province of Ontario. Right? So I see a lot of realtors who are misinformed. They provide the wrong information because they don't know.
Exactly.
Right? Another thing that I'm noticing is on lease negotiations from one realtor to another, usually the listing agent doesn't know that, hey, I can't put a no pet clause here, or I can't ask for 5 months deposits to be put towards the last 5 months of the tenancy. And when the cooperating broker tries to educate them, they get all this defensive, and the cooperating broker loses that deal. Right? I find realtors are not working with each other. They're working against each other. That makes everybody's job difficult.
So what if a student comes and they offer to pay 1 year in advance?
Okay.
What are the pitfalls of that?
They can pay voluntarily, but if that student, and I find that it's happening a lot, they're just doing it so that they can secure the property because nobody else will rent to them. Once they get the keys, a week or two after, they bring an application and say, hey, landlord, I want my money back. Yeah, that's what's happening a lot.
Eek.
A lot.
Okay, and even if they don't, and the 1 year term expires, you may never see rent again.
That's right.
And then what are you going to do? You give keys to someone, you get a tenancy, you got a tenant for life, guys. Right?
You do.
Be very cognizant of this when you are placing tenants on behalf of your clients, right? Or listing a property for rent. These are things you have to know. So it's great that you have the resources on how you can add to the searches to see if this tenant is good. Another thing that I saw recently, I know somebody's having a problem with a tenant. I didn't put them in there. When I looked at the original documents that the tenant provided, there was no address on her documents, no address. So how can you check to see where they were living before? And that was very curious to me because a driver's license or anything like a passport doesn't have your home address on it. So how do you check to see the reference that they're giving you is actually where they are living or were living before, so that you can contact that landlord? But let's talk about, you get a call as a landlord, or you as a realtor are doing some of the due diligence on behalf of your client, and you call the current or previous landlord. If the landlord says something like they never paid, they were sloppy, there were bugs in the unit because of them, and they were just noisy, is that landlord breaking any rules?
Not at all.
Good.
Not at all.
As
The
long as
landlord,
it's true.
as long as it's truthful, absolutely.
Okay.
There's no law that says references have to be positive,
Right.
right? They don't.
So yeah, because I know, okay, some people would say, well, it's human rights, you shouldn't have told them that I was a bad tenant. basically.
Well, they didn't say you're a bad tenant. They just answered the question, is the
Right.
rent being paid on time? No, it's not.
Right.
If
Right.
it's
Okay.
not, it's not. I mean, we tell tenants that all the time, and we have to provide them with reference letters when we end the tenancy. We can't say that the rent was paid on time, right? If it's not paid on time,
Oh, yeah, you
we
can't lie about it. Yeah.
can't lie about it.
So what you're
Yeah.
saying is the realtor has to ask the questions
Yes.
and the landlord can answer honest.
Ask the questions. Ask the question. Same way you're pre-qualifying your buyers because you don't want to show them 100 houses when they have no mortgage approval, right?
Exactly.
Same way, ask them the questions. You know, how long have they been a tenant? Do they pay the rent on time? When is the rent due? Who else is living in the property? Ask these questions.
And I mean, it's good practice to add the condo rules if you're putting a tenant into a
100%.
condo, because then they see the rules and they can agree to them. And if it says you can only have, this number of pets or this type of pet is not acceptable, you get them to initial beside the pet clause or the no smoking or whatever it is. Even
Yeah.
vehicles are restricted. If the truck is too big, it's restricted.
That's right.
Or if it has, in some cases, if it has company logos on it, it's restricted as well. They can't park it in the underground parking. Okay. Sometimes some of my agents who are working with renters hear this. My landlord wants to accept your offer, but they just want to meet the tenant first. What could go wrong?
Many things. Many things. I mean, can we talk about human rights a little bit?
Absolutely.
Okay. Housing is a human right? Everyone has the right to housing in Ontario. That includes non-citizens, that includes citizens, that includes people of color, that includes everybody. Everybody has the right to housing. Here's the issue with trying to meet someone in person or trying to get photo ID is rejecting an application. When you reject an application, there's a preconceived notion that, well, they don't like the way I look. They don't like my head covering. They don't like my kippah. They don't like the fact that I'm a female. They don't like the fact that I'm transgender, whatever the case is. That is discrimination.
Oh, yeah.
And if they look good on paper and you've done your research, before you ask any question, ask yourself, what I'm going to ask, is it relevant? Right? The way they look, is it relevant to the tenancy? Right? If it's not relevant, don't ask that question. Right? It doesn't matter where they're from. It doesn't matter how they look. Right?
So let's say your landlord says, yeah, but I want to meet them.
If you do your
How to handle that a different way with it so that nobody gets in trouble?
If you do your due diligence, you can check them out on social media. You can see what they look like without saying, hey, Sandra, can you bring your clients? I want to see what they look like. Yeah. Another way is to hold kind of like, I call it a mini open house. And this is what I do for my own tenants, prospective tenants, is I either send out a rental application, and I say, well, for those, send it back to me for those ones that, I vetted, come to the property, walk through the property so we can meet one another, or come to the property to pick up a rental application. Then you would have already seen that. But you should not be judging them based on the way they look. Mm-hmm. Okay? Do your research.
So guys, if you have a landlord that says, I want to meet the tenant first because I want to get a feel for them, I'm a good judge of character or whatever. Look, they're giving them, the keys to their $1 million place or $700,000 place. I get it. And it's tenants for life, but you have to handle it in a different way. You have to, first of all, guide your landlords to understand that you can't tentatively accept an agreement and then meet the people and then say no. Because
that's right.
That is going to open up a can of worms for you and for them. Trust me. So what you can do, as Bita said, is invite several applicants to come and let your landlord meet them all. Then everybody knows that this is the sort of like auditioning for tenancy. Right. And then if your landlord chooses one of them, and if the tenant agrees, then great. But to say you've gotten an offer from a realtor, let's say, and you have a place for rent representing a landlord, and the realtor says, well, you didn't accept our offer. Why not?
You
I
have a
would
problem.
caution you from giving any reasons why, but
Yes.
what do you think, Bita?
Yes, 100%. I'm with you there. I'm with you
Don't
there.
give a reason. Just say my landlord is continuing to accept applications, to review applications.
That's it.
That's it.
That's it.
Do not, I had a realtor push me once, and I was not going to divulge why. We checked the documents. They were fraudulent. I wasn't going to say that. He should have known those docs were fraudulent, and perhaps he did. And maybe he was
Perhaps he did.
waiting to hang me, right? No.
Right.
And he said, well, can't you just ask your landlord? And I said, you want me to jeopardize my relationship with my client for someone that they don't want to accept? They said, no, that's fine. Moving on. We have other applicants we're going to review. That's all. Even
That's
if the
right.
property stays on the market for a long time, it's none of their business. And you cannot disclose, by the way, details of another offer. So if you get an offer and it's only good till 6 o'clock tonight, and somebody says, I'm going to prepare an offer, and you say, well, I have an offer already. And the agent says, well, what time does it expire? Do not disclose. This is our real estate code. We are not allowed to say, well, the irrevocable is 6 o'clock. No, you're not allowed to say that.
Oh,
See, say nothing, zip it. Don't say anything, you're going to get in trouble. This is
that's
not
a
only
great
for
way to put
rentals.
it.
This is for any offer. As a
Yes.
realtor, you are not allowed to disclose any details. So, and I know many people ask and they ask, well, what's the closing date? Don't ask. Is it firm? You're in multiple
Yeah.
offers. Is that other offer firm? No, you as the
Yeah.
listing agent cannot disclose. Please understand that. That's really off topic, but still kind of part of it.
No, it makes sense.
So Bita, let's say the landlord has hired a realtor, or even just for landlord knowledge, and they agree to a tenant. Tenant moves in and needs accessibility accessories. Can the tenant say to the landlord, please install at your own expense the rail in the shower and other things?
That's a great question. They can, and the landlord must accommodate to the point of undue hardship. Right? What I mean is to the point where they're not going to go bankrupt over it.
Right. The tenant can't say, oh, can you widen the doorways? I mean, they saw the doorways before, right?
That's right. That's right. But if they need a shower handle or these things, the landlord's not going to go bankrupt. I mean, if they need a ramp, well, yeah, that's a lot of money.
Yeah.
Right? Widening the doors, yeah, that's a lot of money.
And you may not even be able to in certain circumstances.
That's right.
And it's a big deal. What are you going to do? You've got another tenant living there. What are you going to go in and start renovating like that?
That's right.
Sorry. So realtors, you should be aware of this. If your potential renter has accessibility issues, you better start asking the hard questions just so that the landlord knows. I'm not saying that the landlord should say, oh, I'm not going to rent to them. Obviously, that's a human right.
That's right.
But I mean, you might have to assist, especially if the owner is out of town or, can't do the work themselves or have the wherewithal to hire the right person. Because don't forget, condominiums have a lot of rules as well. So I don't know that if some of these accessories are going to require condo board approval. And that is a ball of wax too. So let's say you have a tenant and want something that needs condo board approval, then the tenant has to wait while you get the approval.
Yeah. It's no different than waiting for a permit, right?
And if you don't get the approval for it, which I don't think they have the right to do that unless it's a structural thing, then probably the tenant has the right to terminate the agreement. Would that be fair?
A mutually agreement. Yeah. I mean, usually the landlord will say, you know what, I can't accommodate you anymore. And we have to end the tenancy.
Wow. That is such great information, Bita. I'm sure heads are spinning out there listening to this. So I'm really, really grateful. And I love what you do in educating our industry, the real estate industry, on what to do and what not to do. I think it's wonderful. For those of you who haven't taken Bita's courses through TREB, I highly, highly recommend them. They're very informative, and you will be very surprised in most cases. Like you said, you know, there was a top realtor who considered himself a bigwig and he did wrong things. So don't get caught in the line of fire. Do the job properly. If you are going to represent landlords or tenants, please understand, dig in, know more about it, ask us for help, either me or Bita or both of us. We love to help. As you can see, Bita loves to share her knowledge, and she's extremely knowledgeable. So Bita, thanks again so much. Don't forget to click for the download. It's really important information that you can use either for your renters or your landlords. And have a great day, everyone. Thanks, Bita.
Thanks, Sandra. Bye, everyone.